Every legal encounter leaves a trace. Every strict investigation pursues honesty. Comprehending your legal rights, establishing true justice.
You think you're smart? You think you can step over me and make the calls? I've been on this job 20 years. You are nothing. You don't even deserve to wear that patch. I know exactly how you got this job, and it wasn't skill. You don't belong in my car. You keep your mouth shut next time, or I'll make sure you lose that badge. You hear me?
There was a camera recording when those words were said. It had not been planned that way. There was no deliberate setup, no preparation to document what was about to happen on that highway, under that intense blue summer sky. The camera was recording because body cameras record, because that is the protocol, because the person carrying it on their chest had activated the recording the moment they stepped out of the car, the way training teaches you to do, automatically, without thinking, because that is what you do. And then, in a sequence of events that camera would capture with the specific fidelity of devices that do not distinguish between what should be documented and what should not, one officer had looked at another officer and had said two words the camera had recorded with the blue sky behind them, and the highway stretching beyond them, and the summer sun making every detail sharp and irrefutable. You are nothing. The camera had captured that, and everything that came after had begun there. The person who had heard those words was named Officer Marcus Webb. He was 34 years old, had served in the city's police department for 7 years, had received 2 commendations for exemplary conduct, and had left home that morning with his uniform, his duty belt, the body camera clipped to his chest, and the expectation of an ordinary shift on a highway he knew well, because he had worked that route frequently enough to know where the asphalt was worn and where the signage needed maintenance. It was an ordinary service day, until it was not. Until another officer had pulled up beside his cruiser on that open highway and had said those 2 words with the camera recording and the sun beating down and the empty highway in the background as a silent witness to something that should not have been said and that, having been said, could not be undone. The officer who had said those words was named Officer Derek Stone. He was 41 years old, had served in the same department for 12 years, and had arrived at that highway that day in a dynamic that the subsequent lawsuit would describe with a precision that made any argument about ambiguity or misunderstanding impossible. Stone had approached Marcus not because there was an incident requiring intervention, not because there was an ongoing procedure that needed reinforcement, not because any operational protocol had created a legitimate reason for that specific encounter on that specific highway at that specific moment. Stone had approached Marcus because he had seen a black man standing beside a police cruiser and had made a decision about what he was seeing before processing any other detail of the scene, including the uniform, the body camera, and the badge that were visible with the same clarity as the color of Marcus's skin. There was a specific irony in the architecture of this case that legal commentators and journalists who covered it in the weeks after the video became public had noted and described in different ways, but that converged on the same point, that the camera that had captured Stone, saying "you are nothing," was the camera that belonged to Marcus. That was the camera of an officer on duty being treated as though he were not an officer on duty. That was the camera of someone being told they were nothing, recording the person saying it. There was in that inversion a documentary completeness that no subsequent reconstruction could improve because the recording already contained, in the very mechanism that had produced it, the most direct refutation available of what had been said. The camera of someone who is nothing does not exist. That camera existed, and it was recording. If this is your first time on this channel, welcome. This case has a dimension that separates it from others. This channel has examined because here, it is not a citizen being treated differently by an officer. It is an officer being treated differently by another officer. And what that reveals about where prejudice begins and where the uniform ends is something that will stay with you after this video ends. Hit subscribe right now and tell me in the comments, do you think a black officer should have to prove to a white colleague that they belong in the profession both of them chose? Tell me down below. The $200,000 the department paid to resolve the lawsuit that followed those 2 words was a number that had several ways of being read, depending on who was reading it. For some, it was a number too high for 2 words said on a highway. For others, it was a number too low for what those 2 words represented. But there was a reading that the attorneys who conducted the case described as the most accurate available, that $200,000 was the amount the department had calculated was preferable to pay a colleague who had been called nothing than to go to trial with a body camera, showing a uniformed officer saying, "You are nothing," to another uniformed officer on an American highway on a sunny afternoon. That calculation had said something about the case, and the camera had said the rest. Marcus had arrived at that highway that afternoon as the result of a dispatch routing call that had sent his cruiser to that specific section of the road as part of the shift's regular patrol coverage. There was no active emergency, no pursuit, no ongoing incident that had created that moment. There was only the geographic distribution of resources that dispatch does automatically on patrol shifts. And there was Marcus in the cruiser, with the uniform and the camera and the badge doing what officers do when there is no specific call, covering the route, observing, being a visible presence on an open highway on a sunny afternoon. He had stopped the cruiser on the shoulder for reasons the shift records would document as a routine check of a vehicle that had drifted slowly from the flow of traffic, had stepped out of the cruiser, activating the body camera with the automatism of someone who had made that gesture enough times for it to have stopped being a conscious gesture, and had stood beside the cruiser while the vehicle that had drawn his attention continued and disappeared on the horizon without incident. It was at that moment, with Marcus standing beside the open cruiser on the highway, that Stone's cruiser had appeared. Stone had slowed down as he passed the scene, had looked at Marcus, had continued for perhaps 200 meters, and had turned back. That return had been captured by Marcus's camera, which had been active since he stepped out of the car, and it was a detail that Marcus's attorneys would identify as the most revealing detail of the sequence preceding the words, because a deliberate return after an initial pass is not the behavior of someone responding to an incident. It is the behavior of someone who saw something, formed a conclusion, and came back to act on that conclusion. Stone had parked his cruiser behind Marcus's, had stepped out, and had walked toward Marcus with that specific posture Marcus's camera had captured and that anyone familiar with this kind of recording would immediately recognize as the posture of an approach, not of a colleague approaching another colleague, but of an agent approaching a situation they had classified as needing intervention. Marcus had perceived the approach with the training of someone who had spent 7 years developing the capacity to read situations before they became explicit. He had remained standing beside the cruiser with his hands visible, had turned his body slightly toward Stone as he approached, and had waited. Stone had arrived at a distance Marcus's camera captured as the distance of a formal approach, not the distance of a conversation between colleagues on a highway shoulder, and had asked for identification. He had not said hello. He had not asked if help was needed. He had asked for identification with the tone of someone conducting a suspect approach who had not yet recognized, or had recognized and chosen to ignore, that the man in front of him was wearing the same uniform he was, carrying the same badge he was, and had the same camera clipped to his chest that he did. Marcus had responded by identifying himself by name and badge number, which was the functional identifier officers use when communicating with each other in professional contexts, and had pointed to the badge that was visible at chest height. Stone had looked at the badge, had looked back at Marcus's face, and had done something the camera had captured and that had been analyzed by police behavior specialists when the video became public as one of the most indicative elements of the nature of what was happening. He had asked to see the identification again, this time specifying he wanted the full identity with verification, the kind of request made to a member of the public during a suspect approach, and not the kind of acknowledgement extended to a uniformed colleague on a highway shoulder. Marcus had removed the identification holder with controlled movements, had shown the complete credential, and had waited while Stone examined it with the expression the camera captured as the expression of someone receiving information that conflicts with the narrative they brought to the encounter, and who has not yet decided how to integrate that conflict. The camera had kept recording during the silence that followed the examination of the credential. It was a silence of perhaps 8 seconds that had seemed longer in the recording than 8 seconds normally seemed, because there was in it the specific quality of a moment where something was being decided without any of the words of that decision being said out loud. Marcus had remained still during that silence with the credential still in his hand, the highway stretching behind Stone, the sun hitting Stone's dark glasses in a way that made the expression of his eyes impossible to read, but that made the posture of his entire body entirely legible on camera. And then Stone had said the words the camera had captured, And that had become the caption of the video and the reference point around which all subsequent analysis of the case had orbited. He had looked at Marcus, had looked at the badge, had looked back at Marcus, and had said that with that badge or without it, with that uniform or without it, Marcus was nothing. You are nothing. 4 words said. With the blue sky behind them, and the body camera recording, and the American highway stretching on the horizon as if the entire world were a witness, and at the same time were no witness to anything at all. Marcus had remained completely still after hearing that. The camera had captured that moment with the detail cameras capture when the subject of a recording is containing something that containment can barely hold. He had put the credential back in the identification holder with the same controlled movement with which he had done everything else that afternoon, and had said a single sentence the camera had recorded with enough clarity to be transcribed, a sentence that had not been aggressive or said in anger, but that had been said with the precision of someone who had made a decision about what they were going to do with what had just happened. He had said that the conversation was being recorded and that Stone's identification number was being noted, and that everything said on that shoulder would be documented. Stone had looked at the camera on Marcus's chest as if seeing it for the first time. Although there was an identical camera on his own chest that had been recording from the same angle the entire time. Stone had left the shoulder without another word, after Marcus had said everything was being recorded. Marcus's camera had captured that departure. Stone returning to his cruiser, the door closing, the cruiser pulling away on the highway with that disturbing normalcy of something that had just happened and that continued existing only in the recording and in the memory of the 2 men who had been present. Marcus had stood on the shoulder for a moment after Stone's cruiser had disappeared on the horizon. The camera had captured that moment too, the shoulder, the highway, the blue sky, and Marcus standing with the credential back in his pocket and the camera still recording because the camera did not know the relevant part had ended and kept doing what cameras do. Marcus had gotten back into the cruiser, had sat with the engine off for perhaps 2 minutes before turning on the radio and making the call he had decided to make the moment Stone had said those 4 words. He had called the shift supervisor over the standard radio channel, had asked for a private communication on the secondary channel, and had reported the incident with the factual economy that training taught to use in shift reports, identifying Stone by badge number, describing the location and time, and relaying the exact words that had been said. The supervisor had been silent for a moment after the report, then had confirmed receipt and said he would document it, and that Marcus should write the incident report when he returned to the station. There was something in the quality of that supervisor's silence that Marcus had noticed and would later describe with precision. It was the silence of someone who had immediately understood the seriousness of what they had heard, but who was still calculating what it meant institutionally before saying anything that committed to a position before there was more information. Marcus had turned off the radio, had started the engine, and had continued the shift. Because that was what you did. Because the shift did not end because something had happened on the shoulder. Because the highway was still there, and the service was still the service. The incident report had been written that evening before Marcus left the station. He had written with the same precision with which he had made the radio call, identifying each element of the sequence in chronological order, using the technical language that incident reports used and that made each detail verifiable and each allegation specific without unnecessary embellishment or interpretation. He had mentioned the body camera that had been active throughout the interaction and had included in the report the reference to the specific timestamp corresponding to the moment the words had been said. He had handed the report to the shift supervisor and had left the station that night with the clarity of someone who had done what protocol required and who now needed to decide what to do beyond protocol. Because protocol documented what had happened, but did not resolve what had happened, and there was a difference between those 2 things that Marcus had learned with sufficient clarity over 7 years of service to know that documentation was the beginning and not the end. Stone's body camera had been recording throughout the entire interaction the same way Marcus's had been recording, and both files now existed in the department's system as complementary pairs of the same scene seen from different angles. That detail, the simultaneous existence of both recordings, had been the element that the attorneys who took Marcus's case described as the most solid foundation they had found in a police conduct case because it eliminated the possibility of any argument about perspective or interpretation that cases without recordings frequently produced. There was no available perspective that made the 4 words ambiguous. There was no available interpretation that created a context where nothing said by one officer to another on a highway shoulder was part of any operational protocol or any professional interaction the department could defend. Both agents' cameras had recorded the same thing from complementary angles, and the only difference between the two recordings was that one showed Marcus receiving the words and the other showed Stone saying them, and both were equally irrefutable. The department had initiated an internal investigation 48 hours after Marcus's report, after the shift supervisor had escalated the case to the division commander, who had watched both recordings in a meeting with the department chief and the institutional legal counsel. It had been in that meeting, according to sources close to the process who described what had occurred without named attribution, that the legal counsel had said something that had changed the nature of the institutional response from a standard conduct investigation to something that was treated with a different urgency. The counsel had said there were 2 body cameras recording the same interaction, that both were on the department's servers, that any discovery process in any subsequent lawsuit would have immediate access to both, and that the institution needed to decide before any lawsuit existed how it was going to handle a recording that showed one of its agents saying, "You are nothing to a uniformed colleague on an American highway." He had been silent after saying that, according to the same source, letting the implication occupy the space without needing additional elaboration. Marcus had been contacted by an attorney specializing in police conduct cases and civil rights of law enforcement agents 3 days after presenting the incident report. Not because he had immediately sought legal representation, but because the attorney had been referred by a colleague of Marcus's who had gone through a situation involving discrimination in the workplace 2 years earlier, and who had told Marcus there was a fundamental difference between having a documented complaint and having someone who knew what to do with a documented complaint in an institutional context that had every incentive to minimize what had happened. Marcus had met with the attorney that week, had shown him the incident report, had described the interaction with the same precision he had used in the report and the radio call, and had told the attorney he wanted 2 things from the process that followed. He wanted Stone to answer for what he had said, and he wanted the department to answer for the environment that had allowed something like that to be said. The attorney had listened, had asked some questions about Stone's history, about prior complaints, about the department's culture, and had said at the end that he had enough to build a case and that the cameras made that case more solid than most cases he had conducted in his career. Stone's history that had emerged during the discovery process had a structure that Marcus's attorneys described in one of the preparatory meetings as the structure they saw most frequently in cases that reached the formal lawsuit stage. Not the structure of an isolated incident by an agent without prior history, but the structure of a pattern that had existed long enough to be documentable and that had persisted long enough to raise questions about the supervision that had allowed the persistence. There were 3 complaints in Stone's records from the previous 12 years. The first had occurred 4 years after the start of his service, and had involved an allegation of discriminatory treatment in a traffic stop that had been filed away after an investigation that records described in language that was technically neutral, but whose analysis of the volume of documentation produced suggested had been conducted with a brevity inconsistent with the seriousness of the allegation. The second had occurred 2 years later, and had been withdrawn by the complainant before a formal conclusion, which the records documented without additional detail about the circumstances of the withdrawal. The third had been an internal complaint from a colleague, not public, that had resulted in a verbal warning whose specific content was redacted in the records in a way that made it impossible to verify what had motivated the warning without access to documents the department had initially resisted providing during the discovery process. That initial resistance to providing the documents related to the third complaint had been one of the most revealing moments of the discovery process, according to Marcus's attorney, not for what it had eventually revealed when the documents were finally produced under court order, but for what the resistance itself had communicated about what the department knew was in those documents before any production order. When the documents had been produced, they had revealed that the verbal warning had resulted from a situation where Stone had made comments to a black colleague during a shared shift that the colleague had reported as racially motivated, and that the supervisor who had conducted the review had described in his notes, which were part of the file, as concerning but insufficient for formal disciplinary action. That specific document, with that specific language of concerning but insufficient, had become one of the most cited elements in Marcus's lawsuit because it established that the department had previously been informed that Stone had a pattern of behavior that had been internally classified as concerning and had chosen to respond with language that signaled recognition without consequence. Stone had been deposed in a context that Marcus's attorneys had prepared with full knowledge that the cameras eliminated the space available for alternative versions of events, but that still left space for the question of context and intent, which was the space where defenses in cases of that kind normally operated when factual evidence was irrefutable. Stone's strategy had been to frame the words as part of a training dynamic, suggesting he had known Marcus from prior contexts and had used provocative language as a form of pressure response testing, an allegation that had been dismantled during the deposition by 3 sequential reasons Marcus's attorney had prepared with the precision of someone who knew the allegation would be made and had anticipated how he would dismantle it. The first was that shift records showed no prior encounter between Stone and Marcus that established any familiarity sufficient to justify testing language. The second was that no departmental training protocol included or authorized the use of language of that kind in any context. And the third was that Marcus's camera had captured Stone's posture and tone with enough clarity that anyone watching the recording could independently assess whether what they had seen was consistent with training or with something categorically different from training. Stone's camera had captured something that Marcus's camera had not captured with the same clarity, which was Stone's expression in the seconds immediately before he said the words. Stone's camera was positioned on his chest, pointing slightly upward at the characteristic angle of body cameras, and had captured Stone's face as he bent slightly to examine Marcus's credential, and then straightened to look at Marcus's face before speaking. Behavioral analysis specialists who had been consulted by Marcus's attorneys described what the camera captured in those seconds as the sequence of expressions of someone who had received information contradicting a previously formed expectation, the credential confirming Marcus was a police officer, and who had made a deliberate choice to ignore that information in favor of the conclusion they had brought to the encounter. That specific detail, visible in Stone's recording but not fully captured in Marcus's, had been described by Marcus's attorney during settlement negotiations as the element that transformed the case from a case of words said impulsively into a case of words said after the information contradicting them had been received and processed, which was a distinction that had legal implications about the question of intent that were difficult to ignore. The internal investigation had concluded in 6 weeks with a dismissal recommendation that had been the fastest the department had produced in a conduct case involving discriminatory language in the previous 8 years, according to sources familiar with the department's history. That speed had been interpreted differently by different observers, some seeing it as a sign the department had immediately recognized the gravity of what had happened and had responded proportionally, others seeing it as a sign the department had immediately recognized the risk of going to trial with those cameras and had treated the speed of internal resolution as a form of damage control before the civil lawsuit established the pace of the public narrative. Those two interpretations were not mutually exclusive, and there was available evidence to support elements of both, which was precisely the kind of ambiguity that cases where institutions respond quickly, but for reasons that mix genuine recognition with strategic calculation frequently produced. Stone had attempted the appeal the union had filed on his behalf, and the arbitrator had denied it after a hearing where the cameras had been the central element. The arbitrator had written in the decision's findings that he had watched both recordings 4 times before writing the decision, and had reached the same conclusion on each viewing, that there was no available interpretation of the recorded words that made them compatible with acceptable professional conduct in a department that had explicit policies on discriminatory language in the workplace, and that the existence of prior complaints in Stone's record made it impossible to treat the incident as an isolated deviation without established pattern. The decision had been cited in subsequent legal analyses as an example of arbitration findings that used body camera evidence with a specificity that arbitrators in prior cases without recordings rarely managed to apply for lack of comparable objective material. The civil lawsuit had been filed in state court 3 weeks after the conclusion of the internal investigation, in a timing that had been deliberate in the same way other elements of Marcus's strategy had been deliberate since the first radio call that afternoon on the highway. Marcus's attorney had explained the reason for the timing in one of the preparatory meetings, with a clarity that Marcus would later describe as the explanation that had transformed his understanding of what he was doing from a personal complaint into a strategic process with objectives that went beyond his individual case. Filing the lawsuit after the conclusion of the internal investigation meant the lawsuit benefited from the investigation's conclusions as corroborating evidence without being limited by them. Because the internal investigation had concluded that Stone had violated departmental policies, but had stopped short of quantifying the harm or addressing the question of institutional responsibility for the pattern that had allowed that behavior to persist for 12 years. With 3 complaints and a verbal warning as the accumulated response. The lawsuit had been built around 3 central allegations that operated in layers of progressive legal complexity and progressively greater institutional responsibility. The first was the most direct, racial discrimination in the workplace by a colleague, grounded in the words captured by both cameras and in Stone's history that established pattern. The second was institutional supervisory failure, grounded in documents showing the department had been informed of Stone's behavior through 3 complaints over 12 years, and had responded in ways the lawsuit argued were systematically insufficient to produce behavioral change, with the verbal warning for the third complaint being described specifically as a response that had documented recognition of the problem without imposing a consequence capable of modifying the pattern. The third allegation was the one that had generated the most internal debate before being included, and that Marcus's attorney had described as the most important for the objectives Marcus had articulated from the beginning, which was the allegation that the department had created and maintained a work environment where a black officer could be approached by a white colleague as a suspect on a highway, where the words "you are nothing" could be said to a uniformed officer on duty, and where that officer had completed 7 years of service without the department having implemented sufficient policies or training to make that encounter impossible or at least unlikely in its most extreme form. The department had responded to the lawsuit with the strategy departments use when factual evidence is irrefutable, but institutional responsibility is contestable, which was to concede the basic facts while contesting the characterization of the institutional response as systematically inadequate. It had agreed that Stone had violated policies, had agreed that the internal investigation had concluded correctly, had agreed that dismissal had been the appropriate response. It had contested the allegation that the history of responses to Stone's prior complaints constituted institutional negligence, arguing that each complaint had been investigated in accordance with the procedures in effect at the time, and that the adequacy of historical procedures should be evaluated by the standards of the time, and not by the standards the lawsuit was applying retroactively. That line of defense had encountered an obstacle Marcus's attorney had anticipated. The third complaint, the internal one from a black colleague, had been made only 18 months before the incident with Marcus, and the procedures in effect at that time were the same procedures in effect at the time of the incident, which made the argument of evaluation by historical standards inapplicable to the most recent element of the pattern the lawsuit was establishing. The video had become public during the negotiation period that had occurred in parallel with the formal lawsuit, not as the result of any strategic decision, but as the result of a public records request that had reached the department from a journalist who had received information about the lawsuit's existence through the court's public records. The publication had occurred at a moment when negotiations were at a phase where the department had made an initial offer that Marcus's attorneys had rejected as insufficient in both the financial amount and the institutional conditions, and had created additional pressure on the negotiation process that both sides had calculated differently. The department had calculated that the video increased the urgency of a resolution before the public narrative became more difficult to manage. Marcus's attorneys had calculated that the video strengthened their position in the negotiations without eliminating the need to continue pressing for institutional conditions the department had shown reluctance to accept. The reaction to the video had a specific dimension that distinguished it from other police conduct videos that had circulated in the same months, which was the dimension of how the audience watching it processed the fact that both men in the recording were police officers. There had been comments that had circulated widely that touched on that element in ways that revealed something about how people process discrimination within institutions that are frequently framed as monolithic in public discussions about policing, but that are composed of people who experience those institutions in dramatically different ways depending on who they are. Black officers from across the country had shared the video with comments describing similar experiences with a specificity that indicated what had happened to Marcus on a highway was not anomalous, but was part of a set of experiences that existed inside police departments the same way it existed outside them, that the uniform did not eliminate prejudice, but compressed it into interactions that were frequently more difficult to process because they happened in a context where professional fraternity should be the dominant element and where the reality of prejudice made that fraternity asymmetric in ways the uniform did not resolve. Marcus had given an interview during that period to a publication specializing in law enforcement and civil rights issues, the only one he had granted before the case's resolution, and had said something that had been cited in subsequent analyses with a frequency indicating it had touched on a point that longer and more elaborate analyses had tried to articulate without achieving the economy Marcus's words had achieved. He had said that the hardest thing about what had happened on that highway had not been the words themselves, although the words were what was documented and what the lawsuit was addressing, but had been the confirmation that the uniform was not protection against the kind of assumption that had motivated Stone to return after passing, and that confirmation had come from a colleague who had taken the same oaths as him, who had gone through the same training as him, and who had chosen on a highway shoulder on an ordinary day to treat those oaths and that training as secondary to an assumption that the training should have eliminated and that the oath should have prohibited. The $200,000 agreement had been signed 4 months and 11 days after that afternoon on the highway, in a negotiation process that had been longer than the final amount suggested when considered in isolation, because the amount had been the easiest element to negotiate, and the institutional conditions had been the element that had consumed most of the time and energy on both sides. The department had arrived at the $200,000 figure with relative speed after the cameras had been watched in formal negotiations, and after the department's attorney had made the assessment that legal advisors make when evidence leaves no space for alternative narrative. What had taken longer were the pages of the agreement that had no numbers, the pages that described what the department had agreed to change in the way it operated, and those pages had been negotiated with an intensity the financial amount had not required, because the department had understood that the operational changes had implications that would persist long after the check was deposited. The condition that had been most resisted by the department, and that Marcus had told his attorney was non-negotiable from the first meeting, was the condition on specific field colleague recognition training. The department had argued that agents had procedures for identifying other agents, and that those procedures were sufficient. Marcus had told his attorney that Stone's camera had shown Stone examining Marcus's credential and saying, "You are nothing afterward," which was the most direct documentation available that existing procedures had not been sufficient in that specific case, and that the insufficiency had not been accidental but had been a choice. The agreement had included the condition, drafted with a specificity that made compliance verifiable, requiring documented semi-annual training on interactions between agents from different units, with specific emphasis on authority recognition and colleague approach protocol, with a completion assessment that could not be satisfied by attendance alone, but required demonstration of understanding of the scenarios presented. There was a second condition that had been included at Marcus's attorney's insistence more than at Marcus's insistence, but that Marcus had supported after understanding the implications. It was the condition on the automatic complaint escalation mechanism, which required that any second complaint against an agent within a 5-year period be automatically escalated to a supervisory level above the direct supervisor without the direct supervisor's discretion about that escalation, and that any third complaint be automatically referred to a review conducted by an evaluator external to the department. That condition had been the one the department had resisted most vigorously, arguing that it eliminated necessary supervisory discretion and created bureaucratic processes that would compromise operational efficiency. Marcus's attorney had responded that Stone's history had 3 complaints over 12 years that had been handled with supervisory discretion, and that the result of that discretion was documented on 2 body cameras on an American highway. and that if there was a case to illustrate what happened when supervisory discretion was the only escalation mechanism in situations with established pattern, that case was precisely this one. The condition had been included in the agreement. Stone had left the department without possibility of further appeal after the union's third instance had been denied. He had attempted to obtain employment at 2 departments in adjacent counties, and in both cases, the records that included the dismissal and the discriminatory conduct notation in the employment file had resulted in rejection during the background check phase. Marcus's attorney had learned of those attempts through channels he had not detailed but had mentioned in a conversation with Marcus, and Marcus had responded with something the attorney had later described as the response that had revealed more clearly than any formal statement Marcus had made throughout the entire process what had motivated every decision he had made since that afternoon on the highway. Marcus had said he had not sought to prevent Stone from working elsewhere. He had sought for the record to exist, so that anywhere Stone tried to work could make an informed decision about what it was hiring. The difference between those two things mattered to him, and had mattered in every decision about what to include and what not to include in the agreement's conditions. Marcus had returned to service during the negotiations period, had completed the shift that had been interrupted by the afternoon on the highway and by everything that had followed, and had continued doing what officers do when there is no specific call, covering the routes, observing, being a visible presence on the highways he knew well. Colleagues had approached him during that period in different ways, some with the direct solidarity of people who understood what had happened and what it had cost, others with the discomfort of people who were close to something that disturbed categories they had depended on to organize their experience of the institution where they worked. Marcus had navigated those interactions with the same economy with which he had navigated everything else since that afternoon, without dramatizing, without minimizing, present in the work in the way the work required. The agreement had been announced in a joint statement that had been shorter than statements in similar cases normally were, and the brevity had been noted by people following these cases as a sign that both sides had reached a resolution that had not left either of them with excess language to offer. Marcus had given a 1-paragraph statement that had been published alongside the statement, and that had said the agreement was fair, and that the institutional conditions were the outcome he had sought since he had written the first report that night after returning from the shift. He had said the camera had done the work cameras are supposed to do, which was to document what happened regardless of who was being documented, and that what had happened on that highway had mattered not because it had happened to him, but because it happened, which was the distinction that had driven every decision he had made about how to respond. The following morning, Marcus had left home with the uniform and the camera clipped to his chest and had activated the recording the moment he stepped out of the cruiser, as he always did, automatically, without thinking, because that was what you did. The camera had begun recording, and the highway had been there as it always had been, open, long, with the blue sky above and the asphalt stretching on the horizon, waiting for the shift still to come.
You still haven't told me why you pulled me over, Sheriff.
Ma'am, vehicles like this are often flagged for theft. Just need to verify ownership.
Flagged for theft? I've driven this car for 3 years. It's in my name.
That may be, but someone in your situation driving a car like this raises questions.
She had left home that morning of February 14th, 2025, with the same routine as any other work morning. She had had coffee, had checked the day's schedule on her tablet, had picked up the folder with the documents she would need at court, and had walked out the front door of the house where she lived in that residential neighborhood, with its large homes and leafless February trees against the blue sky of a cold morning. The car she had gotten into was white, was luxury, and was hers, purchased with 23 years of a career in a profession that rewards decades of competence with the kind of financial stability that allows certain choices. She had started the engine, had put on her seatbelt, had pulled out of the residential street toward the highway that led to the courthouse where she had worked for 8 years. It was an ordinary Tuesday morning. There was no reason for it to be anything else. And then the lights of a police cruiser had appeared in the rearview mirror. The officer's body camera had begun recording before he reached the driver's window. This was visible in the timestamp, 10:42 in the morning, on a day in February 2025, and had captured the agent's approach to the white car with that specific image quality that body cameras produce when winter sunlight hits metallic surfaces, slightly overexposed, with colors mildly flattened, but with enough clarity that every detail mattered. What the camera had captured when it reached the height of the driver's window was a middle-aged black woman in a royal blue blazer and gold necklace with her right hand still on the steering wheel. Looking at the officer with that expression, anyone who has ever been stopped without reason immediately recognizes the expression of someone who already knows what is happening before a single word is spoken, and who is calculating in real time how to respond in a way that does not worsen a situation that should not be happening. The woman sitting in that white car was named Dr. Catherine Morris. She was 52 years old, had been appointed federal judge 8 years earlier after a career that had included 15 years as a public prosecutor and 6 years as a constitutional law professor at a university whose name appeared on the country's best law schools lists. She had been appointed through a process that involved Senate review, had been confirmed by vote, and exercised jurisdiction over a federal district covering a considerable geographic area, with a population that included the neighborhood where the officer had turned on his cruiser lights behind her car that February morning. She had spent 8 years applying the law with a precision that attorneys who appeared regularly in her courtroom described in terms that consistently converged around two characteristics: that she was rigorous with evidence, and that she treated everyone who appeared before her with the same demands and the same respect, regardless of who they were. On that February morning, a police officer had decided she needed to prove who she was before she could continue on her way to work. The officer had said there was an irregularity with the vehicle's license plate. That had been the initial justification, though a license plate irregularity, communicated with the technical language officers use when they need an articulable reason for an approach and choose the vaguest available criterion. Catherine had heard that, had looked at the officer with the expression the camera had captured, and had done something the camera had also captured, and that any attorney or judge would immediately recognize as the behavior of someone who knows the process that is about to happen. She had become very still, had kept her hands visible, and had begun processing every word with the attention of someone who knows that every word being said and every word being answered is being recorded and that that recording will matter. If this is your first time on this channel, welcome. What that body camera captured on that residential street in February 2025 is one of the most extraordinary recordings this channel has ever analyzed, not for the rarity of what happened, but for the specific identity of who was sitting in that car, and for what that identity revealed about how the system fails, even the people who were placed inside it, to ensure it does not fail. Hit subscribe right now and tell me in the comments, do you think a federal judge should have to prove who they are to an officer in an unjustified stop? Tell me down below. The license plate irregularity that had been cited as the reason for the stop would be verified during the subsequent process, and the result of that verification would be one of the most cited elements in legal analyses of the case in the weeks that followed. There was no irregularity. The plate was correctly registered, the vehicle registration was current, the insurance was active, and there was no pending issue of any kind. Associated with that car or that plate in any system, the officer could have consulted before turning on his cruiser lights. What there was a white luxury car being driven by a black woman in a residential neighborhood of large homes on a Tuesday morning, and the camera had captured the approach that combination had produced with enough clarity for the entire world to watch and draw its own conclusions about what had motivated those lights to appear in Catherine Morris's rearview mirror on that Valentine's Day morning. The officer had arrived at the driver's window with that posture body camera's capture with a fidelity that human memory rarely manages to replicate. The posture of someone who had made a decision before getting out of the car and was implementing that decision with the specific confidence of someone who does not expect the decision to be questioned. He had asked for the driver's license and vehicle registration with the tone of someone making a request that presumes immediate compliance. Catherine had opened the glove compartment with deliberately slow and visible movements, had removed the documents, and had handed them through the window with her right hand, while the left remained visible on the steering wheel. That gesture, of keeping the left hand visible while moving the right, was the gesture of someone who had learned, through a combination of legal training and lived experience, that every movement in a police stop has the potential to be interpreted, and that the interpretation can have consequences the movement itself does not justify. The officer had examined the documents for a time the camera had captured as longer than necessary to verify the validity of a driver's license and vehicle registration document. During that time, Catherine had kept her hands on the steering wheel looking forward, and the camera had captured that profile of her. The blue blazer, the gold necklace, the upright posture of someone containing a reaction, while simultaneously processing what is happening and what they will do about it. Other cars had passed on the residential street during that time, some slowing slightly when passing the cruiser with its lights on, the kind of deceleration drivers make when they see a police stop. And that is simultaneously curiosity and caution. None of those cars had stopped. The scene had happened with that quality of public visibility and simultaneous invisibility that defines many of the situations this channel examines. The officer had returned the documents and had asked a question the camera had captured with enough clarity to be transcribed word for word. He had asked what Catherine was doing in that neighborhood. He had not framed the question in any operational context. He had not said there was an incident in the area, or that there was an ongoing search or any other reason that made the question functionally connected to any legitimate policing objective. He had simply asked what she was doing in that neighborhood, with the specific tone of a question that presupposes that the person being asked needs a reason to be where they are. Catherine had responded that she lived in that neighborhood, had pointed in the direction of the street she had left a few minutes earlier. The officer had looked in the direction she had pointed, with an expression the camera had captured, and that anyone watching would describe as the expression of someone who has received information they had not anticipated, and who is still deciding what to do with it. It was at that moment that Catherine had said something the camera had captured, and that had initiated a second phase of the interaction that was qualitatively different from the first. She had said, with that calm the camera had recorded, as the calm of someone who chose each word carefully before opening their mouth, that she was a federal judge and that she needed to know what the legal justification for the stop was because she had not committed any traffic violation and the car's documentation was entirely current. She had said this not as a threat or as intimidation, but as information, the same way any citizen has the right to ask for the justification of a police stop, with the difference that Catherine knew with a technical precision that few citizens possess exactly what the law required as the basis for that stop, and exactly what the absence of that basis meant legally. The officer had been silent for a moment after hearing that. The camera had captured that silence with the same fidelity with which it had captured everything else. The mention that she was a federal judge had produced in the officer's behavior a change the camera had documented in enough detail that anyone watching could identify the exact moment it occurred. It had not been a dramatic postural change or an immediate verbal reaction. It had been a subtler change in the speed of subsequent responses, in the frequency with which the officer's eyes had gone to the camera on his own chest and returned to Catherine, in the slightly different quality of the tone he had used in subsequent sentences compared to previous ones. It was the change of someone who had received information that altered the situation's calculation, but who had not yet completely decided how to integrate that information into what they were doing. Catherine had observed that change with the attention of someone who had spent 8 years observing how people behave when processing new information in a context of pressure, which was essentially what happened in a courtroom every day, and had continued waiting with her hands on the steering wheel. The officer had asked Catherine to wait and had returned to his cruiser. He had been in the cruiser for 9 minutes, according to the body camera timestamp that had continued recording throughout that time. During those 9 minutes, Catherine had stayed in her car with the engine running and had done something the camera had not captured because it had happened inside the vehicle, but that she would later describe with a precision that made the scene completely visible without any image. She had picked up her phone, had opened the Notes app, and had begun typing. She had typed the cruiser number she had seen in the rearview mirror when the lights had appeared. She had typed the time. She had typed the exact street. She had typed every word of the interaction up to that point that she could remember with enough precision to trust. And she had typed the question the officer had asked about what she was doing in that neighborhood, in quotation marks, because that specific question had been sufficiently precise in its inadequacy to merit exact preservation. The officer had returned from the cruiser after 9 minutes, with a change in posture the camera had captured, and that was different from the posture with which he had first arrived at the window. There was in him now something that was not exactly retreat, but was adjacent to it. The posture of someone who had made a consultation during those 9 minutes that had produced enough information to alter his assessment of the situation without him having yet decided how to articulate that alteration. He had told Catherine that the plate had been verified and that everything was in order. He had said this without mentioning what the verification had found or failed to find, without explaining why a 9-minute verification had been necessary for a document that was completely regular, and without answering the question Catherine had asked before he returned to the cruiser. The question about what the legal justification for the stop was. Catherine had noted the absence of that answer with the precision of someone who had spent 8 years in a profession where the difference between what was said and what was asked was frequently the most relevant element of any interaction. She had asked the question again, not aggressively or with the tone of someone looking for a confrontation, with the same calm that had characterized every moment of the interaction up to that point, and that the camera had captured as the calm of someone who had made a decision about how to behave before the stop began, and who was maintaining that decision, regardless of what was being said or done around her. She had asked the officer to describe the specific traffic violation or observable behavior that had motivated the stop, because without an answer to that question, the stop had no legal basis, and she needed to understand whether what had happened had been a mistake or something different from a mistake. That specific formulation, the distinction between a mistake and something different from a mistake, had been captured by the camera and had been analyzed repeatedly by legal commentators in the weeks that followed as an example of language that was simultaneously precise in its technical meaning and absolutely clear in what it was communicating beyond that technical meaning. The officer had responded that he had thought the plate appeared irregular when he had passed the car. Catherine had asked what specifically had appeared irregular. The officer had said the angle had seemed different. Catherine had been silent for a moment after hearing that, a silence the camera had captured and that anyone who had watched a trial would recognize as the silence that precedes an observation that will be precise. She had said that license plates had angles because they were mounted on brackets that had angles, and that her plate's angle was the standard factory installation angle that had been there since she had purchased the car. She had said that and then had been quiet again, leaving. The officer's response to occupy the space she had created. The officer had not filled that space with anything the camera could record as a substantive response. There were other houses visible in the camera's background throughout that entire interaction, the large homes of the residential neighborhood where Catherine lived, and where the officer had decided that a white luxury car driven by a black woman justified turning on the cruiser's lights. That framing detail, the neighborhood in the background, had been noted by several of the commentators who had analyzed the video when it became public, because it added a layer of context to the scene that made the question about what Catherine was doing in that neighborhood even more revealing than it already was. She was not in a different neighborhood from her own. She was on the street she had left that morning, on her way to work, in a car she had purchased, in a neighborhood where she had been paying property taxes for years. The question about what she was doing, there was a question about the right to presence in a space that was specifically her space, and the camera had captured that question with the houses of that space visible in the background, with a documentary completeness that no screenwriter could have deliberately constructed. A second officer had arrived during the interaction, dispatched by the first after he had returned from the cruiser, and had parked behind the original cruiser with its lights also on. The arrival of the second officer had been captured by the first's camera, and had added an element to the scene that attorneys who would analyze the case would describe as disproportionate escalation, because the stop of a supposedly irregular license plate, which had been verified and had resulted in nothing, had produced 2 cruisers on a residential street with lights on a Tuesday morning. The second officer had stayed beside his cruiser, observing the interaction without approaching. Catherine's car, a position the camera captured in the background, and that had the visual effect of making the scene larger and more formal than any available justification could explain. Catherine had looked at the second car in the mirror and had returned to looking at the first officer with that expression the camera had captured from the beginning, and that had not changed throughout the entire interaction. She had said she was going to need the officer's full identification number and the stop report number because she was going to file a formal complaint. She had said this not as an ultimatum, but as information about what was about to happen, the same way she had said she was a federal judge, as relevant data that the other party in the interaction had the right to have. The officer had provided the information. Catherine had typed it into the phone, which still had the Notes app open from the period when she had been waiting in the cruiser. And she had put the phone back in the cup holder had placed her right hand back on the steering wheel and had waited for the officer to say whether she was free to go, because she knew she needed to hear that explicitly before putting the car in motion, because the camera needed to capture that moment too. Catherine had arrived at the courthouse 23 minutes late that morning of February 14th. She had parked in the space reserved for judges, had picked up the folder with documents from the back seat, and had entered through the court personnel access with that posture that people who worked with her described as her posture on any day, upright, direct, with no external sign that that morning had been different from any other morning. The hearing that had been scheduled for 10 had been rescheduled for 11 by the court clerk when it became clear Catherine would not arrive on time, and the attorneys who had waited in the hearing room had been informed only that there was a delay without additional explanation because Catherine had instructed the clerk to that effect when she had called from the car during the 9 minutes she had waited for the officer to verify a plate that had no irregularity. She had conducted the day's hearings with the same precision as any other day. The attorneys present that morning had not noticed anything different in Catherine's behavior during the hearings, which was itself a relevant data point about the specific quality of control she had exercised over that morning's experience. The capacity to enter a courthouse after having been stopped without justification on her own street, and to conduct hearings with the objectivity the function required without letting one experience contaminate the other. It had been only at the end of the day, after the last hearing had concluded and the court staff had left, that Catherine had sat in her chambers and had made the calls she had decided to make since that moment in the stopped car when she had begun typing in the Notes app. The first call had been to the county police department director, not to a subordinate or to a service line, but directly to the director, whose direct number Catherine had because she exercised jurisdiction over cases involving that department frequently enough for the direct number to be operationally relevant information. She had described the incident with the factual economy of someone who had spent decades doing exactly that, identifying the relevant elements of a situation and communicating them in the sequence and with the level of detail that made the situation comprehensible without unnecessary embellishment. She had given the officer's identification number, the cruiser number, the body camera timestamp she had discreetly consulted during the stop, the question about what she was doing in that neighborhood with the exact words she had typed in the Notes app, and had said she expected the body camera recording to be preserved and that it would be available when formally requested in the days that followed. The director had listened without interruption, had asked 2 questions at the end, both factual, about the exact time and location, and had said he would verify personally. That commitment to personal verification in a call received at 6 p.m. on a business day had been the first indicator that the department had made an immediate assessment of the seriousness of what had been reported and had decided that the appropriate response was personal and direct rather than delegated. The second call had been to an attorney specializing in civil liability of public agents with whom Catherine had worked in prior cases in different capacities and who had answered on the first ring when he had seen her name on the screen. He had listened to the account with the attention of someone simultaneously evaluating what they are hearing as a story and what they are hearing as a case, and had said at the end that the element of the question about what she was doing in that neighborhood was, in his words, the element that transformed a documentable discriminatory stop into a documentable discriminatory stop with intent stated out loud and captured on camera. The department had initiated an internal investigation the following day, which was a response speed that those who followed police conduct cases described as unusual, and that had been attributed to 2 factors that rarely coexisted in a case of that kind. The first was Catherine's identity, because a formal complaint from a federal judge about a state officer's conduct created an institutional dynamic that did not exist when the complaint came from a citizen without institutional position, not because a complaint from a citizen without position should carry less weight, but because the operational reality of departments was that complaints from people with institutional power produced faster responses regardless of any formal policy about equal treatment of complaints. The second factor was the body camera, which had been recording since before the officer reached Catherine's window and had captured every moment of the interaction with a completeness that made any alternative version of events impossible to construct credibly. The internal investigator who had been assigned to the case had watched the complete recording on the first day of the investigation, had prepared a complete audio transcript and had identified 4 specific moments he had marked as priority analysis points. The first was the initial stop, which the recording showed had occurred without any visible traffic violation or observable behavior that could have motivated the decision to turn on the cruiser lights. The second was the question about what Catherine was doing in that neighborhood, which the recording captured with enough clarity to be transcribed and that had no articulable connection to any legitimate policing objective. The third was the license plate angle justification, which had been presented after 9 minutes of verifying a document that had no irregularity and that the investigator had described in his notes as the weakest justification he had encountered in a stop report in 18 years of internal investigations. And the fourth was the arrival of the second officer, which had escalated police presence in a situation that had not justified the presence of the first. The video had become public 12 days after the stop, not through any action by Catherine or her attorneys, but through a public records request made by a reporter who had received a tip about the incident from a source inside the department who had watched the recording during the first days of the internal investigation and had made the decision that people inside institutions sometimes make when they see something they believe the public needs to see. The request had reached the department at a moment when the internal investigation was still ongoing and when the department had not yet made any formal decision about what to do with the officer involved, which meant that when the video had been made available in response to the public records request, it had been made available in a context where no resolution had been announced, and where the contrast between what the recording showed and the institutional silence about that content had been immediately and widely noted. The reaction to the video had followed the pattern that recordings of that kind produce when the evidence is sufficiently clear, and when the central element of the scene contains something that transcends the usual divisions of who tends to align with which position in police conduct cases. The question about what Catherine was doing in that neighborhood had functioned in that recording the way the officer's question to Ayla at the IHOP had functioned in the body camera of that case, as the moment that condensed in explicit language the assumption that had motivated the entire interaction, in a way that made it impossible for anyone watching to argue there was another interpretation available. There was not. The camera had captured an officer asking a black woman what she was doing in the neighborhood where she lived, and had captured that on a street whose large houses were visible in the background, and had captured Catherine's response saying she lived there, and had captured the officer's silence after that response. Any analysis that attempted to construct an alternative narrative needed to begin by explaining that specific sequence, and there was no available explanation that held up. Civil rights organizations had issued statements in the first 48 hours after the video's publication. Bar associations had issued statements. Judges' associations had issued statements, some with language that was unusual in its specificity, naming the officer and describing the behavior captured in the recording with a directness that kind of organization normally avoids in public statements about individual cases. Elected representatives had called for independent investigations, and there was a category of reaction that had been perhaps more widely cited than any of those institutional statements, which was the reaction of attorneys and judges across the country who had shared the video, with comments that touched on a dimension that institutional statements did not fully capture, the dimension that what had happened to Catherine was what happened to black citizens who were not federal judges in similar situations, without a camera, without institutional position, and without the precise legal knowledge Catherine had applied in every second of that interaction. That specific angle had been what had given the case a resonance that went beyond outrage at the treatment of a federal judge, which would have been sufficient on its own, but that had created a broader conversation about what Catherine's experience revealed, about experiences that were not documented on body camera and were not conducted by people with the training to respond the way she had responded. Catherine had said in one of the few statements she had made during the period prior to the case's resolution that what had happened to her had happened because of who she was, and that there were people who lived the version without camera of that experience regularly without the resources to do what she was doing about it. That statement had circulated widely and had been cited with a frequency that indicated it had resonated in a way that longer and more elaborate statements frequently do not resonate, because it had said in 2 sentences what many longer analyses tried to say in many more words. The department had announced the conclusion of the internal investigation 28 days after the stop, which was also 16 days after the video had become public. The conclusion had been that the officer had violated departmental stop protocols by having no articulable justification based on objective observation before turning on the cruiser lights, had violated conduct protocols by asking questions that had no connection to any legitimate policing objective, and had escalated the situation disproportionately by calling reinforcements in a situation that had not justified the initial presence. The investigation had recommended dismissal. The director had agreed with the recommendation and had announced the officer's dismissal in the same statement that announced the investigation's conclusion, a timing choice that had been read as a signal that the department had decided that the speed of resolution was as important as the resolution itself. The civil lawsuit had been filed 2 days after the dismissal announcement, and the timing had been deliberate in the same way that the timing of several prior elements had been deliberate, as the result of a strategy that had been thought through from the first days after the stop, with an attention to detail that reflected what happens when someone with Catherine Morris's training and experience directs that competence toward a situation that had happened to them. The lawsuit named the officer individually, the department as an institution, and the county as the entity responsible for supervising the department, and had been constructed with a specificity that attorneys who analyzed it described as a document that had been prepared by someone who knew exactly what a judge looks for in a lawsuit, because they had spent 8 years being that judge. The agreement was signed 43 days after that Valentine's Day morning, at a speed that had surprised even the most experienced attorneys following the case, because lawsuits against police departments rarely resolve in less than 2 months, even when the evidence is clear, and even when the dismissal of the agent involved has already been announced. The speed had been attributed by people close to the negotiations to a factor that was simultaneously obvious and rarely articulated with that clarity. The county had assessed that each additional day without resolution was a day the video continued circulating. The department's name continued appearing in legal analyses and discussions about police conduct, and the distance between what the recording showed and any defensible narrative continued being the central element of every conversation about the case. The rapid resolution had not been institutional generosity. It had been calculation. The financial amount of the agreement had been substantial, confirmed by sources close to the process as being among the largest paid by the county in individual civil rights cases, with a specific component that had been negotiated at Catherine's insistence and that had not been seen in prior department agreements. A portion of the amount had been designated as a fund dedicated exclusively to training agents on stops in residential neighborhoods, with an oversight committee that included representatives from community organizations, and that had authority to approve the curriculum before implementation and to audit execution afterward. That condition had transformed part of the money the county had paid to resolve the lawsuit into a mechanism that existed specifically to reduce the likelihood that the situation that had generated the lawsuit would repeat itself, and had been described by civil rights specialists who analyzed the agreement as one of the most creatively constructed conditions they had seen in a case of that kind. The officer had been dismissed before the agreement was signed as a result of the internal investigation, and the dismissal had included a notation in the employment record that prevented rehire in any law enforcement capacity in the state. The union had filed an appeal that had been denied on second review after the arbitrator had watched the complete recording and had concluded in his findings that the question about what Catherine was doing in that neighborhood had no available operational interpretation that made it part of any legitimate police protocol, and that the absence of any observable justification for turning on the cruiser lights was documented by the agent's own body camera in a way that made the defense based on operational discretion impossible to construct without contradicting what was recorded on that camera. The union had attempted a third instance. It had been denied with language even more direct than the second. The institutional conditions of the agreement had been more extensive than the financial conditions in terms of pages negotiated, which was an indicator of the priority Catherine had given from the beginning to outcomes that existed beyond her individual case. There was a complete revision of stop protocols with documentable criteria that each agent would need to be able to articulate before turning on a cruiser's lights. not after the stop, as had been the case with the license plate angle justification, but before, with registration in the dispatch system of what the justification was at the moment the decision was made. There was a system of stop pattern analysis by agent and by geographic zone that would automatically identify statistical anomalies that could indicate systemic discriminatory behavior before individual cases reached the stage of formal complaint. And there was a condition that had been the most debated in negotiations, and that Catherine had described in one of her meetings with the attorneys as the most important of all. Any agent who asked a question during a traffic stop that had no articulable connection to the registered justification for that stop would be subject to automatic review without need for formal complaint from the stopped party. The case had produced consequences that spread beyond the county in ways that had become documentable in the months following the agreement. Departments in other states had revised their stop protocols citing Catherine's case as a reference. Law schools had incorporated the recording into constitutional law and civil rights courses as an example of documentation of a discriminatory stop with direct evidence. Police training organizations had developed curriculum materials based on the analysis of the 4 moments the internal investigator had identified as failure points. Not because Catherine's case was unique, but precisely because it was not. Because the patterns the camera had documented were patterns that existed in stops that were not recorded or that were recorded, but did not reach the level of public attention this case had achieved. Catherine had returned to the courthouse the day after the agreement was signed, had conducted the scheduled hearings with the precision of any other day, and had responded to the questions of journalists waiting outside the courthouse with a brevity that had frustrated some, and that had been exactly right according to others. She had said the agreement was fair, and that the institutional conditions were the outcome she had sought from the beginning. She had said the body camera had documented what it had documented, and that the system had functioned the way it should function when evidence and determination are simultaneously present. And she had said, before going back into the courthouse, that the following morning she would drive the same car, down the same street, at the same time, because that was the way to work, and because no stop on a February day was going to change the route she took to work. She had entered through the court personnel access without looking back. At 10:42 the following morning, the white car had passed down the same residential street with the large houses and the trees still leafless in the late winter, and there were no cruiser lights in the rearview mirror, just the road.
I need to see your papers. Are you a U.S. citizen?
Yep, born in Chicago.
What's this about? I'm asking a simple legal question. What's my violation? What have I done wrong?
Just show me the goddamn papers.
The question he asked was the simplest possible. He wanted to know what his violation was. He wanted to know what he had done wrong. It was not an aggressive question or a provocation. It was the direct question of a man who had spent decades of his life serving a country that was now, in a parking lot on a sunny day, demanding that he prove he had the right to exist in it. The agent in front of him did not answer immediately. The second agent in the tactical vest stood in the background watching, and the body camera that had begun recording before any word was spoken captured every second of that scene with the precise indifference of a device that does not know what it is documenting but would document anyway, because that is what cameras do. What that camera had documented in that parking lot that day would be enough to change everything that came after. The man standing in that parking lot with that question in the air had served in Vietnam. He had been deployed at 18, had spent 14 months in a theater of operations that produced in a specific number of people who experienced it a kind of memory that does not dissolve with time, but integrates in ways that each person who carries it manages as best they can. He had come home with honors, had rebuilt a life with the determination of someone who learned that rebuilding is what you do when what existed before can no longer be recovered, and had reached 68 years of age with the kind of presence that decades of experience produce in people who pay attention to what life teaches. There was in that posture, even in the adversity of that parking lot, something the camera captured, but that no camera can fully capture. The specific dignity of someone who knows who they are, regardless of what anyone else in that moment is saying or doing. The agents who had approached him in that parking lot belonged to an immigration and customs enforcement unit operating in that region of the state. They had arrived in 2 cars, had positioned themselves in a way the body camera captured as the tactical configuration of a planned operation and not a casual encounter. and had approached the man while he was in the parking lot with a list of items he had purchased at the store beside it still in his hand. There were eggs in the bag. There was bread. There was the kind of purchase a person makes when stocking the kitchen for an ordinary week. And there were 2 federal agents asking him to prove who he was because his appearance had led someone to a conclusion about his citizenship that the reality of his history disproved with a completeness that would be documented in detail in the weeks that followed. The man's name was Leonard. He was 68 years old, had been born in the state where he was now standing in that parking lot, had received his Vietnam draft notice at 18, like any other American citizen of his generation who had reached that age at that specific historical moment, and had served with a distinction recorded in military documents that existed in a federal archive that any government agency could access, with a query that would take less time than the interaction happening in that parking lot. After military service, he had worked for 32 years at a distribution company, had retired with the pension that work had produced, and had spent the subsequent years in a routine that included the grocery store every Thursday morning, because Thursday was the day the sales changed, and Leonard had developed over decades the kind of domestic efficiency that comes from paying attention to details most people do not think are worth attention. If this is your first time on this channel, welcome. This story has a specific layer that separates it from other cases this channel has examined, because what the ICE agents did in that parking lot did not happen in a vacuum. It happened in the context of a specific policy, in an operation with defined targets, and the questions it raised went beyond that parking lot and that day. Hit subscribe right now and tell me in the comments. Can you imagine being a war veteran and having to prove citizenship to government agents in your own country? Tell me down below. The body camera had captured Leonard's question with a clarity that made any argument about what had been said impossible. 4 words that were also 4 questions. What was the violation? What had he done wrong? The agent in front of him had responded with language the camera had recorded, and that Leonard's attorneys would analyze repeatedly in the weeks that followed. Language that avoided answering the question while creating the appearance of responding, that used terms like routine verification and operational protocol to substitute for the answer that did not exist, because there was no answer that held up. Leonard had listened to that language with the expression the camera captured as the expression of someone who recognizes when a non-answer is being packaged in words that sound like an answer. He had served in an army that used that kind of language. He knew the difference between communication and cover, and the question he had asked, what was the violation, what had he done wrong, remained in the air unanswered, because the true answer was that there was no violation and nothing wrong beyond the conclusion someone had formed about who he was before verifying any fact. Leonard had arrived at that grocery store parking lot at 10:17 on that Thursday morning, as he had done on practically every Thursday for the past 6 years since he had retired and established the routine that retirement allows when you no longer need to organize time around an external schedule. He had parked the truck in the same spot he usually parked, had taken the list he had written the night before on a notebook page that he folded and placed in his shirt pocket, and had done the shopping with the methodical precision of someone who knows every aisle of that specific store and knows exactly where each item is without needing to search. He had spent 23 minutes inside the store, had paid at the register with the same employee who served him frequently enough to recognize him by name, and had come out through the automatic doors with 2 bags and the list crossed out entirely because he had found everything he had planned to find. The agents had arrived at the parking lot some minutes before Leonard came out of the store. There were 2 unmarked vehicles positioned in ways that the body camera one of them was carrying had begun recording before Leonard appeared through the automatic doors. This was visible in the recording, and was a detail that Leonard's attorneys would identify as relevant. The agents were positioned and recording before Leonard came out, which meant the approach had not been the result of spontaneous observation of behavior in the parking lot, but had been planned before Leonard appeared, which raised a question that would be central to the lawsuit, the question of how Leonard had been identified as a target before he was in the parking lot, and what had underpinned that identification. The agent who had made the initial approach was named, according to records that would be obtained during the discovery process, Supervisory Agent Daniel Walsh. Walsh had approached Leonard shortly after he came out through the automatic doors with the bags, had identified himself as an ICE agent, and had asked for identity documentation. Leonard had stopped, had looked at the agent, and had asked that question the camera captured, and that would become the most shared caption of the video when it reached the public. He had asked what his violation was, what he had done wrong. Walsh had responded that it was a routine verification and that he needed to see a document. Leonard had said he was American, that he had been born in that state, and had asked whether there was any law that required an American citizen to carry proof of citizenship to do grocery shopping. That question had hung in the air for a moment before Walsh responded that he just needed to verify identity and that it would be quick. What Leonard had been carrying in his wallet that day was what most people carry in an ordinary wallet: his driver's license, some cards, a health insurance card, and a veteran's military service card he had carried since receiving it. After military service 50 years earlier, and that had become so integrated a part of that wallet's contents that Leonard sometimes forgot it was there, until a situation like that, one made it the most relevant object of everything he possessed. He had removed the wallet from his pocket, had shown the driver's license first because that was what most people showed when someone asked for identification, and Walsh had examined the document for a moment before saying he needed something that confirmed citizenship status. Leonard had looked at the agent with that expression the camera captured and had removed the veteran's card from the wallet. The veteran's card had been examined by Walsh with the second agent who had approached during that time. The two had exchanged a few words in low voices that the camera's audio had captured with insufficient clarity for transcription, but with enough to establish that an exchange was occurring. Walsh had then told Leonard he needed to verify the information in the system and that it would take a few minutes. Leonard had asked whether he was being detained. Walsh had said no, that it was a voluntary verification. Leonard had responded with the precision of someone who knows the difference between the legal categories Walsh was using, had said that if it was voluntary, then he was ending his cooperation and continuing with his day. Walsh had said it would be better for Leonard to cooperate. That phrase, that it would be better for Leonard to cooperate, had been captured by the camera with enough clarity to be transcribed, and was the phrase Leonard's attorneys would later describe as the moment of voluntary verification had become implicitly coercive, because the suggestion that it would be better to cooperate in an interaction the agent had just described as voluntary created a pressure that made the voluntary character of the interaction a fiction. Leonard had stayed in the parking lot, not because he had agreed that it was better to cooperate in the way Walsh had suggested, but because he had made a calculation that any black man of his generation would understand without need for explanation. There were 2 armed federal agents in a parking lot on an empty weekday morning. There was a camera recording. And there were decades of experience that taught that the difference between a situation that resolves without incident and a situation that resolves otherwise frequently depended on decisions made in the first minutes about how to respond to what was being done. Leonard had stayed, had kept the bags in his hand, and had continued asking questions with that direct precision of someone who knows that every question and every answer is being recorded and that it matters, even when it is not yet possible to know exactly in what way it will matter. The system verification had taken 17 minutes. 17 minutes during which Leonard had stood in the parking lot with the grocery bags in his hand in the sun of a summer morning, while Walsh operated a tablet and the second agent remained positioned a few meters away in a configuration the camera captured with enough clarity that anyone watching would understand. There was nothing voluntary about Leonard's presence in that parking lot, regardless of the language Walsh had used to describe it. Other store customers had passed through the parking lot during those 17 minutes. Some glancing briefly toward the scene, others looking away with the kind of artificial hurry people develop when they see something that discomforts them, but that they do not know how to process. None had stopped, none had asked anything. The scene had happened with the specific invisibility of things that occur in broad daylight, but that context makes difficult to intervene in. During those 17 minutes, Leonard had asked 3 more questions the camera had captured. He had asked Walsh's full name and the agent identification number, information Walsh had provided after a hesitation the audio had recorded as a pause of perhaps 4 seconds before the response. He had asked on what legal basis the verification was being conducted, specifically which statute or regulation authorized ICE agents to approach American citizens in grocery store parking lots and demand proof of citizenship without any specific probable cause. Walsh had responded with a reference to general operational authority that had cited no specific statute and that Leonard had immediately identified as a non-answer, saying he had asked for the legal basis and not a description of the agency's general authority. He had also asked whether Walsh's supervisor was available to be contacted at that moment. Walsh had said he was the supervisor in the field on that operation. The verification result had arrived on Walsh's tablet 17 minutes after Leonard had been approached. The camera had captured Walsh looking at the tablet, had captured the expression that crossed his face at that moment, and had captured what he said next, which was the kind of sentence that reveals, by the way it is constructed, that the person saying it understands there is a problem with what was being done, but is not yet ready to name that problem directly. Walsh had said that Leonard's information had been verified and that he was free to continue his day. He had not apologized, had not explained what the verification had found, had not acknowledged any inadequacy in the approach. He had simply declared that Leonard was free, as though the freedom of a 68-year-old man to do grocery shopping in the city where he was born were something that needed to be declared by a federal agent after 17 minutes of verification. Leonard had stood still for a moment after hearing that. The camera had captured that moment with the detail cameras capture when something is happening that has no movement but has weight. Then he had said something Walsh had clearly not expected and that the camera had recorded with enough clarity to be transcribed word for word. He had said he wanted Walsh's full name again, the operation number being conducted, the second agent's identification number, and the location of the ICE office responsible for that operation, because he had served in that country for 14 months in Vietnam, and was not going to go home and forget what had happened in that parking lot as though it had not happened. Walsh had provided the information with that same 4-second hesitation that had characterized the first time his identification number had been requested. And Leonard had retained everything mentally with the precision of someone who had learned decades earlier that information retained at the right moment is frequently the only protection available. What the verification had found, and that would become public during the discovery process of the subsequent lawsuit, was that Leonard did not appear in any ICE record as an investigation target. There was no deportation order associated with his name. There was no ongoing immigration status verification process related to him, and that the Social Security number associated with his name identified him unambiguously as an American citizen born in that state with decades of documented tax, Social Security, and military service records in federal archives that any government agency could access. The verification had confirmed in 17 minutes that Leonard was exactly who he had said he was from the first second of the interaction. What it had not explained, and what the lawsuit would attempt to establish with the precision the available evidence permitted, was why that verification had been necessary in the first place. What had placed Leonard on an approach list for an ICE operation in a grocery store, parking lot in an American city on a Thursday morning? There was an answer to that question that emerged from documentation obtained during the discovery process, and that was simpler and more disturbing than any complex operational explanation could be. The operation Walsh was part of had been conducted in that specific neighborhood, based on a profile that internal documents described as identification of individuals with phenotypic characteristics consistent with undocumented populations of Latin American origin. Leonard had no Latin American origin. There was nothing in his history, his appearance, his behavior, or any other observable characteristic that connected him to that profile beyond one characteristic. The documents did not mention explicitly, but that the sequence of events made inferable with a clarity that Leonard's attorneys would describe as the best documented inference they had constructed in a case in many years of practice. Leonard had been approached because he was black, because he was in a neighborhood where the operation was active, and because someone had made a decision about who he might be before verifying any fact about who he was. Leonard had arrived home that Thursday with the grocery bags and with something more he had brought from that store's parking lot. The absolute clarity that what had happened that morning was not something a complaint call to a general customer service number would resolve. He had put the groceries away with his usual meticulousness, had placed the eggs in the refrigerator, had folded the bags and stored them in the drawer where he kept bags because Leonard was the kind of person who reused bags, and then had sat at the kitchen table with a notebook and had begun writing. He had written the names he had memorized in the parking lot, Walsh and the identification number and the second agent's number, and the description of the tablet and the exact time he had noted when Walsh had arrived and the approximate time at which he had been released. He had written all of this in the organized handwriting of someone who had learned decades earlier, in military service, that precise records save, lives in contexts where the official version of events can diverge from what actually happened. The call he had made that afternoon had not been to any complaint line or to any elected representative. It had been to a man named Gerald, who had served with Leonard in Vietnam, who had returned to the same city, and who had spent the last 20 years working as a paralegal at a civil law firm after completing law school at 52, with the specific determination of someone who decides late that they need tools they did not have. Gerald had listened to the complete account without interruption, had asked 3 questions at the end, had said that Leonard needed an attorney specializing in 2 fields simultaneously, civil rights and federal litigation against government agencies, and that he knew exactly the right person. He had also said that Leonard needed to do one thing before anything else: formally request the body camera recording of the agents present in the parking lot before the mandatory preservation deadline expired. Leonard had asked what that deadline was. Gerald had said it varied by agency and jurisdiction, and that the safest answer was to act as if it were tomorrow. The formal request had been sent the following day, drafted with Gerald's assistance and addressed to the ICE office responsible for the operation, with a copy to the Inspector General's Office of the Department of Homeland Security. That copy to the Inspector General had been a strategic decision that the attorney who would take on the case 2 weeks later would describe as one of the most intelligent he had seen a client make before having legal representation, because it had created a record that the request had reached a supervisory level that made any subsequent loss of the material much more difficult to treat as accident or technical failure. The request had identified the agents by name and identification number that Leonard had memorized, had specified the time and location of the incident, had described the requested material with enough precision that there was no ambiguity about what was being asked, and had established that the material was needed as evidence in connection with a formal complaint about federal agent conduct that was being prepared. The attorney who took on the case was named Victor Reyes, had 46 years of federal litigation experience, and had conducted lawsuits against government agencies, with enough frequency to have developed the kind of mental map of those agencies' defense mechanisms that only builds through years of repeated encounters with the same tactics in different contexts. When he had watched the recording for the first time, he had been silent for a few minutes after the video ended before speaking. He had said there were 2 elements in that video that, individually, would support a solid lawsuit. Together, he had said, they created something that, in his words, was difficult to defend by any attorney who needed to make that defense while looking at that video at the same time as looking at a jury. The first element was Leonard's question: what was the violation? What had he done wrong? And the absence of any answer that held up. The second was the veteran's card, which had been examined by the agents and that established with an absolutely devastating symbolic economy that the man they were treating as a suspect of illegal presence in a country had served that country with weapons in hand, while many of his contemporaries had found ways not to do that. The lawsuit had been filed in federal court with allegations covering 4 distinct categories. The first was unlawful detention because the interaction had been described as voluntary by Walsh, but had been conducted in a way that made Leonard's departure implicitly impossible without the consequences that the suggestion it would be better to cooperate had communicated. The second was racial discrimination by a federal agent, grounded in documentation obtained during the discovery process that had revealed the operation's profile and the absence of any criterion beyond physical appearance that could explain Leonard's approach. The third was violation of Fourth Amendment constitutional rights because the verification had occurred without established probable cause and without any genuine consent that the coercive context of the interaction could have produced. And the fourth, which had been the most debated internally before being included, was specific harm to a war veteran whose identity as an American citizen had been questioned by agents of the government he had served, an allegation that had no direct precedent in jurisprudence, but that Victor had argued with sufficient theoretical basis to be included as an alternative the court could consider independently of the other 3. The agency had responded to the lawsuit with the kind of response that government agencies produce when they need to defend actions that available evidence makes difficult to defend. They had invoked operational discretion, had argued that Walsh had acted within the limits of his authority as a federal agent, and had attempted to frame the interaction as the result of a good faith error in an operation with legitimate objectives. That line of defense had collapsed in distinct phases as the discovery process had revealed the operation's internal documents. The profile criteria used, and the history of approaches the operation had conducted in that neighborhood in the weeks before and after the incident with Leonard, a history that had shown a pattern that made the characterization of an isolated good faith error progressively impossible to maintain, with documentary evidence pointing in the opposite direction. The operation's internal documents obtained during the discovery process told a story that was more detailed and more problematic than any narrative the agency had publicly produced about the incident with Leonard. The operation had been authorized 6 weeks before the day Leonard had left the store with his grocery bags, had been designated with an internal code the documents used consistently, but that Leonard's attorneys had identified as irrelevant to the lawsuit, and had been described in the authorization documents as an enforcement initiative focused on geographic areas with high concentrations of undocumented populations of Central American and South American origin. That geographic and demographic description had been the basis on which agents had been instructed to identify approach targets, and the training documents associated with the operation had described the identification criteria in a way that specialists consulted by Leonard's attorneys had evaluated as functionally equivalent to racial profiling authorization. Because the observable criteria agents had been instructed to use in identifying targets were phenotypic criteria that any honest analysis would recognize as proxies for race and ethnicity and not as objective indicators of immigration status. Walsh had been deposed 6 weeks after the filing of the lawsuit. The deposition had lasted 4 hours and 20 minutes, and had been conducted by Victor with a methodology that observers present described as the methodology of someone who had prepared each question with full knowledge of what the most likely answer would be and how each answer related to the body of documentary evidence already in Leonard's attorney's possession. Walsh had responded with the consistency of someone who had been prepared by the agency's legal team, but had encountered an obstacle that legal preparation can never completely eliminate when documentary evidence is sufficiently specific. There were moments when the answer preparation suggested and the answer the documents made defensible were different answers, and at those moments the testimony had produced inconsistencies that Victor had documented with precision and that had become a central part of the evidence archive. The most revealing question of the deposition had occurred in the 3rd hour, when Victor had asked Walsh to describe the specific criterion that had motivated the approach to Leonard in that parking lot. Walsh had said he had observed behavior consistent with the operation's profile. Victor had asked him to describe that behavior specifically. Walsh had said that Leonard had been standing in the parking lot for a time, that had seemed inconsistent with someone who had done grocery shopping. Victor had then presented the store's point-of-sale system, records showing the exact time Leonard had paid and left, and had calculated out loud the time between Leonard's exit through the checkout and Walsh's approach, which had been approximately 90 seconds. He had asked whether Walsh considered that 90 seconds between leaving a store and being approached by federal agents who had already been positioned in the parking lot before Leonard's exit constituted a time inconsistent with someone who had done grocery shopping. Walsh had been silent for perhaps 8 seconds before responding that there were other factors. Victor had asked him to list those other factors. Walsh had listed 2 that the operations documents contradicted and had fallen silent after the second. The video had reached the public during that period, not through any deliberate strategy of Leonard's attorneys, but through a process that had begun when a journalist covering EACE had obtained information about the lawsuit's existence and had requested access to the case's public records, which included references to the body camera that by that point had already been preserved and transferred to Leonard's attorney's control through the appropriate legal mechanisms. The recording had been described in enough detail in an initial article that demand for the complete video became immediate and intense. When the video had eventually been made available as part of the case's public records, it had accumulated more than 12 million views in 72 hours, a number that had surprised even the platforms where it had circulated, and that had transformed Leonard's case into a reference point in discussions about ICE practices that had been occurring in policy circles, but that the video had brought to a dramatically wider audience. The public reaction had created pressure on the agency that had operated in parallel with the legal pressure, and had interacted with it in ways that legal strategists on both sides had attempted to calculate with limited precision, because that kind of interaction between public pressure and legal process rarely follows predictable models. Veterans organizations had issued statements that had been particularly effective in terms of media coverage because they had combined the language of service and sacrifice with a specific criticism of the agency that was difficult to dismiss with the framings the agency normally used to respond to criticism of its practices. Elected representatives had called for investigations. The Inspector General of the Department of Homeland Security had opened an independent review of the operation that had been conducted in that neighborhood, a review that had occurred in parallel with Leonard's lawsuit, but that had been initiated by the copy of the evidence preservation request that Gerald had advised Leonard to send on that second day after the incident. Walsh had been removed from field duties during the Inspector General's review, in a decision the agency had announced without explicitly connecting it to Leonard's lawsuit, but that occurred on a timeline that made any other causal connection impossible to construct credibly. The second agent had received an administrative assignment while the review was ongoing, and the entire operation had been suspended 4 weeks after the video had become public, in a decision the agency had described as protocol review, but that internal documents obtained during the discovery process would later show had been precipitated by the Inspector General's review's preliminary conclusion that the profiling criteria used in the operation were not defensible under federal anti-discrimination legislation applicable to immigration enforcement activities in American territory with a citizen population. The agreement was signed 11 months after that Thursday morning in the parking lot. Victor had conducted the negotiations with the specific patience of someone who knows that time is not working in the opposing party's favor, and that each additional week without resolution is a week in which the operation's internal documents remain as public record of the process, and in which the recording continues accumulating views and references in discussions about immigration policy that the agency would prefer not to be feeding. The agency had made 3 offers before the final agreement, each revealing through the amount offered the assessment it had made of the risk of going to trial with that body camera as central evidence and with the operation's profiling documents as established context. The first offer had been rejected by Victor without immediate counteroffer, with a note explaining that the amount demonstrated the agency had not yet made the correct assessment of what was at stake. The second had produced a counteroffer. The third had produced the agreement. The financial amount of the agreement remained partially confidential by negotiated clause, but sources familiar with the process confirmed it was among the largest ever paid by the agency in an individual civil rights violation case, and that there was an additional component that was not part of the principal amount, but had been included as a separate condition. The agency had agreed to pay the mental health treatment costs Leonard might require in connection with the documented effects of the incident, without value limit and without expiration date, a condition Victor had included in the negotiations after Leonard had described in one of their preparatory meetings what he had experienced in the weeks after the parking lot. The nights he had woken with the physical clarity of being back in that space with the bags in his hand and the agents around him, the specific difficulty of a man who had survived Vietnam and who had built decades of life after that, processing that the government of that country had questioned his right to exist in it in a grocery store parking lot on an ordinary morning. The institutional conditions of the agreement had been the longest to negotiate and had been the ones Leonard had defended most firmly in every meeting with Victor about what was and was not negotiable. The operation that had produced the incident had been permanently closed, not suspended for a fixed period but closed, with formal closure documentation that had been included as an annex to the agreement and that existed as a verifiable record independently of any subsequent public statement by the agency. The profiling criteria that had been used in the operation had been formally designated as non-conforming with agency policy, a designation that had been inserted in the operations manual with specific language that made any future operation using similar criteria a documentable violation of internal policy beyond any external legal violation. Walsh had been dismissed as a condition of the agreement, with permanent notation in the employment record. The second agent had received a 6-month suspension without pay and had been required to complete a training program on the constitutional rights of American citizens in immigration enforcement operations. The condition that had been most contested in the negotiations, and that Leonard had told Victor, was the one he would not concede regardless of the impact on the financial amount. was the condition on specific veteran training. Leonard had demanded that the agency implement, as part of the agreement, a mandatory protocol that identified American Armed Forces veteran status as a factor that should be verified immediately in any citizenship verification approach, with a direct access mechanism to the Department of Veterans Affairs database that permitted real-time verification. That condition had met agency. Resistance that had argued operational complexity and interoperability issues between different agencies' systems. Leonard had told Victor, in one of the meetings where this had been discussed, that operational complexity was the argument of people who had not spent 14 months in Vietnam, and that interoperability between federal agency systems was a problem the American government had demonstrated it was capable of solving when it had decided the problem merited a solution. The protocol had been included in the agreement. The Inspector General's review had concluded independently of Leonard's lawsuit, although the two processes had shared evidence through the appropriate legal mechanisms that the operation had violated internal Department of Homeland Security guidelines on permissible target identification criteria in enforcement operations on American territory. That conclusion had been made public in a report that had cited Leonard's case, with his name as a central example, of the operational failure that had been identified, and had recommended systemic changes that went beyond the conditions of the individual agreement, and that had created a second level of pressure on the agency to implement changes the Leonard Agreement had established, but that the Inspector General's report had validated with the authority of an independent federal investigation. Leonard had given an interview after the agreement was signed, the only one he had granted throughout the entire process, to a journalist who had covered the case since the initial article that had described the recording. The interview had lasted 40 minutes and had been published at a length the journalist had justified to the editor by saying there were some stories that aggressive editing diminished rather than improved. Leonard had spoken about Vietnam with the economy of words of someone who had reached the conclusion that some experiences are not explainable but can be referenced. He had spoken about the 32 years of work and about retirement and about Thursdays at the grocery store with that folded list in his shirt pocket. He had spoken about the notebook where he had written the names and numbers that Thursday afternoon after putting away the groceries. And he had said, near the end of the interview, something the journalist had placed as the last sentence of the article because he had immediately recognized it was the sentence that contained everything the article had tried to say in the 42 preceding paragraphs. Leonard had said he had served that country because he had believed in what it represented, and that the process he had conducted had not been to prove he had served, because that was already proven in military documents that had existed for 50 years, but to demand that the country act in accordance with what it represented rather than merely representing it. He had paused after saying that. Then he had said he would return to the grocery store the following Thursday, that there were eggs on the list.
Truth is a continuous pursuit, and awareness is your best defense. Thank you for watching and championing global transparency.